redundancy situation can manifest itself in a number of ways. There may be a diminished need for the work, a diminished need for the employees, or there may be a site closure or the business itself may be closing down. Certain members of staff will be pooled for redundancy, and it's these members of staff that the company will go on to apply certain selection criteria to. If an employer fails to consider the question of pooling in the first instance, it's likely that any dismissal that follows will be unfair. It's also important to consider how long a member of staff has worked for the company. If a member of staff has worked for less than 2 years, then unless they're contractually entitled to a redundancy payment, won't be paid to them. And lastly, if there are less than 20 members of staff at risk of redundancy, there's no minimum consultation period. If there are 20 or more members of staff at risk, then an employer is under a statutory duty to engage in at least a 30-day consultation, and employee representatives will need to be consulted with. Tribunals consider a number of factors in particular. The first one is whether or not the selection criteria is objectively chosen and fairly applied. For instance, a member of staff who has been on sick leave, but the reason for that sickness absence is because they suffer from a disability, that of course can give rise to a claim for discrimination. We'd always consider whether or not employees have been warned and consulted about the redundancy. If there was a trade union, whether or not the trade union's view was sought. And lastly, whether or not suitable alternative positions were considered. There's no positive duty on a company to create a role for someone, as long as there are suitable vacancies at the time. Substantive procedural failures can result in claims for unfair dismissal. We've certainly seen an increase in claims, particularly with the abandonment of tribunal fees, so there's no longer a fee. Ensure that from the outset you have a comprehensive and up-to-date redundancy policy or process. Other things that will help, of course, is engaging with employees as part of that consultation. This can reduce the risk of a claim subsequently being brought. It's important from the outset that an employer has sound comprehensive legal advice as to what the proper procedure is in a redundancy process. Of course, the old saying, prevention is better than cure, and I think that's particularly the case in a redundancy situation where emotions are quite high. So, in my opinion, the best practice will be to seek advice from the outset. We offer a no obligation consultation, so if a client is thinking of having to make redundancies and they're not sure of the process to follow, of course they can contact us at that stage. We have had clients that have contacted us partway through a process or when that process has concluded, and we're able to offer advice at each stage of that process.